global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happenings Today YouTube channel. The struggle to permanently convict Nnamdi Kanu of all the count charges the federal government can muster has begun, despite the fact that the appeal court seemed to stand on the opposite and give maximum freedom to Nnamdi Kanu. It looks like eventually this whole case is going to Supreme Court. And the funny part of this whole thing is the fact that they have listed everything. And I just hope and pray that the legal team of Nnamdi Kanu is ready for the diversion, or rather the direction this whole legal tussle is going, as the federal government has filed 7 grounds of appeal against the October 13th Court of Appeal judgment, which discharged the leader of the indigenous people of Biafra, Nnamdi Kanu. It asked the Supreme Court to set aside the judgment and restore the charge against the respondent to be tried at the trial court. The government, in a motion on notice in report or in support of the appeal, is also seeking a stay of execution of the judgment of the court, presided over by Justice Juma Sankey, pending the hearing and final determination of its appeal, noting that the IPB leader posed a flight risk. The notice of appeal dated October 18 was signed by the Director of Public Prosecution of the Federation, Mohammed Abubakar, Assistant Chief State Counsel, D. Kaswa, and A. Aluko, and Senior State Counsel, G. Nweze, Department of Public Prosecution, Federal Ministry of Justice. The appellant averred that the appellant court erred in law when it held that the trial court had no jurisdiction to try Kanu because of the extraordinary rendition of the respondent. It stated, and I quote, "There was no evidence led by the respondent before the court of the first instance, and indeed before the court below, to show how he was allegedly abducted and rendered to Nigeria, as required by Section 139 of the Evidence Act 2011, since he alleged that he was abducted without following due process of the law." The appellant also contended that the court below erred when it held that the executive arm must not be allowed to benefit from the abduction of the respondent, when in fact, by its judgment, the respondent was allowed to benefit from its illegality of disobeying the courts of the law when he jumped bail and was rewarded with a discharge from the charges pending against him at the trial court, thereby occasioning a miscarriage of justice against the state and the victims of the crimes perpetrated by the respondent. The government claimed that the appeal court was wrong by saying that how Kanu was brought back to the country can vitiate and indeed weaken the criminal charges of treason and treasonable felony and even terrorism brought against him. It added that the lower court made the decision without taking into account the fact that the nature of the entry of the respondent is not relevant in the determination of charges against him. The appellant further stated that the appeal court justice failed to be bound by established judicial precedent on the mode of entry of a defendant charged with the commission of an offense established by the Supreme Court. The appeal court, the federal government noted, misdirected itself when it relied heavily on the Organization of African Union's Convention on the Prevention and Combating of Terrorism, the African Commission on Human and People's Rights, and cases decided from foreign jurisdictions as against the substantive law covering the criminal procedure in Nigeria. The court below overlooked the submissions of the appellant with regards to the ACGA 2015, which takes its taproot from the Grand Norm Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to the effect that it is the Administration of Criminal Justice Act 2015 that governs the trial of every Nigerian charged with the commission of a crime. This failure occasioned the miscarriage of justice, the appeal court notice read. The federal government further argued that the court below erred in law when it discharged the respondent of the offences mentioned in counts 1, 2, 3, 4, 5, 8, and 15, bordering on terrorism offences contained in the amended charge dated January 14, 2022, and retained by the trial court for want of jurisdiction. The appeal observed that the appellant court was completely silent and closed its eyes to the obvious fact of the issues which predate the rendition of the respondent, because he was standing trial for conspiracy and treasonable felony terrorism before his escape. If the learned justices of the Court of Appeal had taken into consideration the act of illegality of the respondent in jumping bail and the corresponding duty of the appellant to ensure his presence in court, the decision of the court would have been different, the appeal read. In an affidavit, Loveme Odubo of the Department of Public Prosecution, Federal Ministry of Justice, stated that Kanu has a history of always jumping bail and may be difficult to secure if the appeal was not granted. The affidavit reads, and I quote, that the respondent is a flight risk person given his previous antecedents of jumping bail while standing trial. The respondent is a dual citizen of both Nigeria and Britain, which makes it easy for him to move out of Nigeria. That the respondent presence will be difficult to secure should the judgment of the law below is not overturned and set aside by the Supreme Court. There is a need to stay the execution of the judgment of this honorable court to avoid a situation where the judgment of the Supreme Court will be overreached and rendered nugatory. Even the Senate Southeast Consensus had this to say. Meanwhile, the Southeast Caucus of the Senate has intervened in the case of the federal government against Kanu, urging that the ruling by the Court of Appeal be obeyed. In a statement jointly signed by 14 Southeast senators as of Thursday, they advised the government against appealing the ruling at the Supreme Court, but rather asked the presidency to utilize the opportunity presented by the appeal court ruling and consider a political solution to solve the lingering problem in the interest of the country's unity and peaceful coexistence of Nigerians. The statement reads, and I quote, "This is the time to show the magnanimity and statesmanship. The appeal court has provided the leeway for the authorities to walk the talk as once desirous of preserving Nigerians' unity and respect for her diversity. Accordingly, we as a caucus and stakeholders in the Nigerian project appeal to Mr. President to remember the promise he made to a delegation of elders of Igbo land some time ago and release Nnamdi Kanu." Oh, well, that's a choice. You can see that the federal government have a different narrative altogether, which means all these fights, all this push by the legal team of Nnamdi Kanu to at least get Nnamdi Kanu free, even if it is for 1 or 2 days before they will appeal. The DSS and the executive have made sure that that particular court injunction of freeing him, even if it's for 24 hours before they will appeal, it didn't come to pass. They still kept him until they appealed. I guess it will now continue. Well, I never saw it in a different light. I always know to probably go this direction because, hey, this is federal government. They always have a way around this. They have the power. Well, let's hope for something a bit different than this. Let's go wrap it up. Let's meet in our comment section. What's your take? Have a nice time. God bless you. Bye.